Sam, will you start the live stream and we'll get the meeting going, please?
Of course, yep. And we are live on YouTube.
All right. Thank you very much. Good afternoon, everybody. I'd like to say it's so nice to see all of you, but I don't actually see all of you. But this is one of the consequences of the medium that we're meeting in, which is a positive. Not that we can't see each other necessarily, but rather that we can actually go forward with this meeting under these circumstances. We are live streaming the meeting. We're meeting on a WebEx platform that the court uses for all of our hearings, and it's served us very well. I can say that too. I really appreciate everybody being online with us here this afternoon. It's an important undertaking that we're going to make, as all of you well know. And in a second, I'm going to go around the table, so to speak, and ask each of you to introduce yourselves by the title of the office that you hold, so that we can identify each other that way. There are a couple of housekeeping things I want to touch on before we get into the heart of the meeting, which will be a presentation by Sarah Friedman and colleagues from CSG. This is a wonderful group who served us so well in the first phase of this effort a year or so ago, even less. The housekeeping things I wanted to mention are these. If you are not speaking, if you'd please mute your computer or your phone or whatever you're working with, which will help delete some of the background noise that can confuse everybody listening. The second thing is there's a chat function for questions that we'd like to ask you to use. The chat hyperlink is located in the lower right-hand corner of the screen. So if you want to ask a question, if you would indicate in the chat function your question, we'll make sure that we get it on the table. If you are having trouble with your connection, the recommendation from experts is that you stop the video stream and only listen in on the audio. And don't forget that we are live streaming on the internet as well. So I'm going to start with Mary Jane Ainsworth. We're going to go down alphabetically. Mary Jane, just identify your role, if you would, please.
Hi, I'm Mary Jane Ainsworth. I am the Executive Director of the Parole Board.
Thank you for joining us. Jim Baker. Jim? You there, Jim? All right. John Campbell. John, are you with us? Okay, let's hope we pick up momentum here. Susanna Davis. Susanna, are you with us? Well, all right, I'm keeping my fingers crossed. Kelly Doherty. Kelly. Are people having trouble with their connections? Sam, can you tell?
Jim Baker won't be on the line today, most likely. This is Judy Henkin, and I'm filling in. I'm the Deputy Commissioner. So that's why Jim Baker's not on. He's in a hearing today.
Thank you very much. Thank you. And how about Kelly? Is somebody here for Kelly? From the alcohol and drug programs at the Department of Health?
Look at this crowd.
No.
I didn't realize it was this big of a meeting.
Alice Emmons. Alice, did you get connected back? All right, Alice is working on it. Pat Gable.
Hi, I'm Patricia Gable. I'm the State Court Administrator.
Thank you. Maxine Grad.
Hello, I'm Representative Maxine Grad, and I chair the House Judiciary Committee. Thank you.
Thank you. Thank you. Jay Johnson.
Oh, I guess they skipped over.
Hi, I'm Jay Pershing Johnson. I'm the governor's legal counsel.
Thank you, Jay. Who did I skip? Somebody said I skipped somebody. Jim Duff Lyle.
No.
Hi, this is Falco Schilling from the ACLU of Vermont. I'm here on behalf of James Lyle.
Thank you. Alice Nitka. I might have said it.
Here, Alice Nitka, State Senator on the Judiciary Committee.
Thank you, Alice. David Scher.
Yes, David Scher, Assistant Attorney General representing the Attorney General's office.
Thank you, David. Mike Sherling. Michael, Commissioner. All right. Dick Sears.
Dick Sears, Benning County Chair, Senate Judiciary Committee.
Thank you. Kendall Smith.
Yes, good afternoon. Kendall Smith, Governor Scott's Director of Policy Development and Legislative Affairs.
Okay, thanks. Sarah Squirrel.
Sarah Squirrel won't be joining. This is Morning Fox, Deputy Commissioner for the Department of Mental Health. I'm representing DMH.
Thank you, Morning. Karen Tronsgaard Scott.
Good afternoon, everybody. I'm Karen Tronsgaard Scott. I'm the Executive Director of the Vermont Network Against Domestic and Sexual Violence.
Thanks, Karen. And Matt Valerio. Anyone here from Defender General? Okay. So I'm going to turn the meeting over to Sarah. And if, as I said before, if you have questions, and if you know, it's possible with a chat, you're not going to get our attention. And if not, wave at your camera. That's my suggestion, my high-tech suggestion. Just wave, you know, with a great deal of passion at the camera, and we'll see it, and we'll get your question. Okay, Sarah, it's over to you.
Great, thank you so much, Chief Justice. I am just going to get the PowerPoint presentation up and running. Hopefully this will only take a second, if you all will just bear with me. Okay, it's loading right now. Okay. Can everyone see this presentation?
Maybe in a minute.
Okay.
Yes, I can see it.
Yes, I can see it.
I can see it.
Okay, wonderful. Thanks. Thank you so much. As I go, I do encourage you to put into the chat box any questions or comments you might have. I'm not sure if in this presentation mode, I will be able to see things. So I'll be pausing at the end of each section to see if anyone wrote something in the chat or wants to speak up if you all are not able to necessarily get my attention while I'm speaking and we're all in this kind of a presentation mode. So once again, thank you so much, Chief Justice, and to the working group members and everyone for having us here. The CSG team is really looking forward to embarking on this second phase of Justice Reinvestment 2 with you all and kicking off this first meeting of the Justice Reinvestment 2 working group post enactment of your Justice Reinvestment legislation. The presentation, which you all received last night, so you can follow along on the screen or on the slides that we sent. It will be in 4 parts. First, I'm going to give a quick kind of overview of the Justice Reinvestment 2 process so far and what it looks like moving forward. Then I'll go into a brief refresher of the policy changes in Act 148, which is your Justice Reinvestment 2 legislation. Third, I'll talk through the technical assistance plan that CSG Justice Center staff plan to provide to Vermont moving forward. And then we'll wrap up the presentation with talking about some expectations for the work moving forward and next steps. So I know that many people on this call and the working group members are really familiar with the CSG Justice Center. We've been working on justice reinvestment in Vermont since 2019 and also have worked in the past on a variety of projects. But just for folks on the line who might be less familiar with who we are, the Council of State Governments Justice Center is a national, nonpartisan nonprofit that works across all three branches of government to help states use data and research to improve their criminal justice policies and practices and increase public safety. We're the criminal justice policy arm of the Council of State Governments, which is an association whose members inform and support our work. We're all here because of justice reinvestment, which is one of the hallmark initiatives of the CSG Justice Center. Justice reinvestment is a data-driven process that CSG staff use to guide states who are looking to improve public safety and address critical challenges in their criminal justice systems. JR is funded by the Department of Justice Bureau of Justice Assistance, and Justice Reinvestment Technical Assistance comes at no cost to state governments or the state of Vermont. Before we get into the meat of the presentation, I want to introduce my CSG colleagues who will be helping Vermont out post-enactment. Many of you already know David Demora, who was around during what we call phase 1 of justice reinvestment, that policy development phase. We're extremely lucky that David is able to stay on and can help with implementation. And he's brings a host of experience and expertise to our team, a content expert in behavioral health, correction systems, best practices, sex offender treatment, and other evidence-based programming. Additionally, you all have, I believe, received several emails from Loretta Sacchi, so her name should look pretty familiar there, and many of you have spoken with her directly. She's a policy analyst on our team who's helping to organize these working group meetings and really guiding stakeholder engagement on CSG's side with folks in Vermont. We also have Madeline Dardot on our team, another policy analyst who is working very closely with David to help implement the policy changes in Act 148 related to state agencies changing their practices and policies and procedures. In a little bit, you'll hear me talk about the BJA subaward grant that's available to Vermont. We're very lucky to have Jan Dela Cruz on our team to help guide Vermont through the grant award application and award process, which we'll talk about in a little bit. And then, as you all remember from phase 2, from phase 1 of this process, justice reinvestment is really data-driven, and our research is a very important component of all of our work. And so we're very lucky to have Angie Gunter on our team, who is taking over justice reinvestment research and will be leading Vermont's state monitoring process, which we'll also be talking about in this presentation. So the history of Justice Reinvestment 2 in Vermont kicks off in June 2019, when leaders from all three branches of government wrote to justice reinvestment funders asking to work with CSG on a JR approach to tackle Vermont's criminal justice system challenges. In this letter, state leaders pledged to work together to identify data-driven solutions for Vermont. As you know, this was actually the second time around Vermont has embarked on justice reinvestment. The state also underwent a JR process in 2008. In tandem with this letter of request, in July 2019, Governor Scott issued an executive order establishing the Justice Reinvestment 2 Working Group, which is you all. We've listed here the original 18 members of the working group who went through that phase 1 process, and that includes almost everyone who's currently on the committee, although a few people have switched over as roles have transitioned. We've also, in this new round with Act 148, an additional member has been added to the committee moving forward, and that is Mary Jane Ainsworth, who's representing the Parole Board. So this timeline here is a reminder of what you all did during phase 1 of the process. The working group met 5 times between August 2019 and January 2020 to examine analyses prepared by CSG Justice Center staff and discuss policy options. This was a really short time frame for a phase 1 process, and a lot of ground was covered extremely quickly, as you'll see in this timeline. At the outset of the project, the working group set goals for how CSG staff should focus our efforts. These included examining the cycle of incarceration, particularly related to people on community supervision and how they end up back in prison, gaining a better understanding of behavioral health challenges in the state and how unmet behavioral health needs contribute to this same revolving door, and determining how to strengthen criminal justice data systems and the state's capacity to conduct data analyses. CSG's analysis of Vermont's criminal justice system took a 2-pronged approach, both quantitative and qualitative. First, we worked with state agencies to obtain and analyze as much criminal justice data as possible. This table should be really familiar to the old working group members, as the phase 1 CSG team displayed it at each meeting to keep you updated on their efforts to access data. In the end, we accessed most of the data we hope to analyze, including crime arrest data, data on pretrial detention, all of the different types of supervision and furlough from Department of Corrections data, victim services, and some behavioral health data. I will note here that we were not totally successful in obtaining criminal history data and unfortunately weren't able to incorporate into our analyses during the short time frame for the project. In addition to this quantitative analysis, the Justice Center team also met and spoke with over 200 stakeholders, doing that qualitative piece to understand what was really going on in the system for people working and currently in the criminal justice system. These conversations focused on understanding front-end pressures, understanding what was going on with incarcerated populations, and then also getting a better understanding of behavioral health in Vermont. And I'm pretty sure almost everyone, if not everyone on this video call, I'm sure has talked to at least one member of the CSG team. But all of those meetings also included meeting with law enforcement officers, victims advocates, court officials, parole officials, housing experts, and people with lived experience, among many, many others. So the next few slides should be pretty familiar to folks who were in this working group process all along. These are the key findings that our phase 1 team presented to you all related to those analyses of the presented at working group meetings. These findings included that some serious crimes have been increasing in Vermont, which is expected to drive more people into the correction system. That although Vermont has taken on many efforts to divert people out of the criminal justice system, these diversions have been adopted inconsistently across the state and with mixed success. We also found a complicated community supervision system with many different statuses and ways someone may be supervised. Additional analyses included that a large proportion of people convicted of misdemeanor offenses received incarcerative sentences and that felony convictions have increased. That supervision revocations have been driving prison population admissions, or prison admissions, particularly concerning returns from furlough supervision for technical violations, and that limited resources in the state have created challenges for the administration of recidivism reduction programming, and that created gaps in addressing people's behavioral health needs throughout the system. My phase 1 colleagues also identified a lot of strengths to Vermont's criminal justice system. Many of these focused on state agencies, that DOC had invested in the use of evidence-based practices, on what research tells us should work to reduce recidivism, and that the Parole Board had worked to incorporate national best practices in their decision-making processes. They also commended the state for the long and robust history of enacting effective criminal justice reform policies and the motivation to continue improving the system now. However, the phase one team did find significant areas for growth to improve Vermont's criminal justice system. You'll notice that this list mostly focuses on, on programming, that the state needs more resources devoted to the implementation of evidence-based practices, programs for people, more programs for people at high risk to recidivate, and gender-responsive programming for incarcerated women. That access to and quality of community-based alternatives to incarceration varies by geography and creating racial disparities in sentencing outcomes, and that similarly, there's varied access to and quality of programs for people on community supervision. They also identified gaps in behavioral health level of care and data analysis capacity. With all the information from these analyses, the working group established a policy framework that set forth 4 goals. These goals were 1, reduce recidivism and revocations to prison; 2, achieve a more equitable system across gender, race, and geography; 3, improve data and reporting to inform decision-making; and 4, reinvest in policy implementation and sustain progress. Despite the pandemic, Vermont state leaders managed to enact a significant criminal justice reform policy package this past July in the form of Act 148. It's really quite remarkable, and you all should commend yourself for being able to focus and get criminal justice policy on the agenda while everything else was going on. I'll go into greater detail on all of the policies listed on this slide in the next section. However, it's important to note here that CSG did recommend a significant investment in programming, community supports and services, and DOC's data capacity to accompany the policy recommendations. We all know that Vermont is coming out of a really tough budget season, and state budgets across the country have been impacted by the pandemic. My understanding is that as of last week, a sum of money was appropriated to support some of the programming recommendations, particularly around domestic violence accountability programs. So also in July 2020, as Act 148 was enacted, state leaders were motivated to reapply to the Bureau of Justice Assistance for continued technical assistance report from the CSG Justice Center. This support was approved in mid-August, which kicked off the work that my team has been doing, meeting with all of you. Leading up to this meeting today, the CSG team has been able to speak directly with 18 of the 19 working group members to talk about what our assistance looks like moving forward. So this should be really familiar to many of you. We've also included a handout in your meeting materials that gives more details on the kind of support that we are providing in this next phase of justice reinvestment. But basically, phase 2 implementation assistance is in 2 main buckets: hands-on project support by CSG staff that lasts 12 to 24 months with its greatest intensity at the beginning of implementation, and a $500,000 grant that passes through CSG from the federal government to help remove barriers to implementation. So this hands-on technical assistance, the staff support component of our work, can be thought of in 3 different ways. 1, we're working on specific projects related to the policy changes passed in Act 148 with your state agencies to help make sure implementation is informed by research and lessons learned from other states. 2, we're helping the state establish performance measures and set up data collection related to the policy changes, and I'll talk more on that in just a second. And 3, we're able to do a lot of stakeholder engagement to make sure that the JR process continues to be collaborative and consensus-based, just like it was before. So a really important part of our technical assistance is helping Vermont set up data measures to measure the outcomes of policy changes. We call this process state monitoring. And Angela Gunter, who's on the call somewhere, really leads this work for our phase 2 team from our research division. She'll be working with state agency IT and research departments to identify a robust set of metrics to track what's going on in the state's criminal justice system. Once this is set up and running, Vermont is required to regularly report out this data to CSG for the duration of the project, and for the duration of the project, meaning the implementation TA that we provide for those 12 to 24 months, and then for 2 years after CSG is no longer in the state. Next, on to the money. So as mentioned before, Vermont is eligible for a pass-through grant of $500,000 from BJA. This is money. This is federal money that is currently with CSG waiting to be sub-granted out, dedicated to Vermont's implementation of justice reinvestment policies. Past states have used this money in a wide variety of ways to support their implementation projects of policy changes. However, there are three very common ways that I'd like to highlight for the working group. First is most states choose to hire someone to help with implementation. We often call them justice reinvestment coordinators, and they can be a position on staff or through a contract to help ensure that implementation runs smoothly. Secondly, states often use a portion of the funding to provide training for line staff, supervision officers and corrections officers, to help them adopt evidence-based practices that are shown to help people in the criminal justice system reduce recidivism. And third, to support all this data monitoring and IT work that is a component of measuring the outcomes of policy changes, states often use this funding to upgrade their IT systems in order to be able to track outcomes. So the way the grant application process works is Vermont actually, although Vermont has a total of $500,000, this can be split up into two separate application processes. BJA allows states to do what they call Category 1 applications, which are a more streamlined version of the application designed for upfront needs, hoping to get the money released to the state quickly at the beginning of the project. Basically, this application is designed to get that staff person in position who will then be supporting the rest of the project. Although there are occasionally, they may approve the funding for other time-sensitive upfront needs. Once that Category 1 application has been submitted, then the state has additional time to put together kind of a larger, more robust package for Category 2 application that is supposed to support other needs identified in state implementation plans. It's really important to note that all subaward applications have to be submitted collaboratively by all of the agencies impacted by implementation, and the funding can really be only used for capacity building supports. That's supposed to be one-time costs, not any ongoing costs that the state might need to pick up at the end of the project. Applications also follow all federal grant lines, and I have a feeling that some people in the meeting here have probably dealt with federal grant making before. It's a little bit of a labyrinthian process, and there's a lot of allowable and unallowable expenses and just like a whole bunch of rules to follow with getting the application in and figuring out what BJA is willing to fund. That's why we have Jan on staff to help guide you through this process, since it's not necessarily super straightforward. So in the process of our work with the Department of Corrections and the Parole Board, we've been talking to them about where they see their implementation needs related to this grant, and how they might envision the Category 1 subaward application, which is the application that goes in first. I do want to note on this slide that all applications do need to be approved by the working group, and this approval comes in the form of a letter from the working group chair saying that the working group supports whatever application is submitted and those funding items outlined. So later on in the agenda, you'll hear from DOC and the Parole Board on what their initial vision is for that Category 1 application, but they are thinking through a staff position for someone to help with all of these different data, all of the increasing data collection capacity, integrity, and analysis within their agencies. We hope that Vermont will get that in very quickly. As I said previously, there's a 6-month window for the state to apply for this funds that started when the state was approved for Phase 2 technical assistance. So the clock started running on August 18th. Which means you have through February 18th to apply to submit both applications for funding. so the last slide of the section, and I'll pause in just a moment to take questions, but that kind of summarizes the technical assistance that we plan on providing to Vermont moving forward. But I do, as I mentioned, we've met with many working group members and other folks who were not part of the working group, and we do have a sense of how much you all appreciated the support of the Phase 1 team led by Ellen Whelan-West, who we're so appreciative of as she passed the baton to us. And that, there's this vision of what justice reinvestment is. So I would be remiss if I didn't pause to just talk about how Phase 2 post-enactment does differ from Phase 1 moving forward. So first, let's talk about how our technical assistance, the CSG Technical Assistance, is a little different. The Phase 1 team did this huge systems analysis for you all and guided the policy recommendations, and the development of legislation. In Phase 2, our focus does shift. Now that there are policy changes have been enacted, we're here to really assist state agencies in implementing them and help them build the capacity for data collection and address other implementation needs, along with communicating outcomes to key state leaders and stakeholders as implementation progresses. Additionally, the data assistance looks a little different. Our Phase 1 team, as you all remember, did a massive historical analysis, looking really back at what had happened in Vermont's criminal justice system. The Phase 2 team is now looking more forward. We want to set you all up to be able to measure the outcomes of policy changes and know what's going on in your system moving forward. So we're looking into how we can improve your data collection and analysis capacity now. And then once data comes in from that reporting to us, we'll help you all analyze it to understand what has happened during implementation specifically. And lastly, the thing to highlight on this slide is just that generally the focus of the working group or the oversight committee does shift from Phase 1 to Phase 2. So you all have, Vermont has chosen to continue their Phase 1 working group, which is wonderful. Oftentimes in Phase 2, we call them oversight committees rather than working groups. But just that a key component and the reason BJA approved Vermont for implementation assistance is that is the 3-branch bipartisan swell of support within your working group in overseeing the implementation and monitoring outcomes of the policy changes, in addition to the other statutory duties that we'll talk about here that Act 148 puts tasks the working group with. So I will pause there and see if any questions came in via chat or if anyone just wants to, raise their hand. And I see Pat Gable is indicating. Yes, hi.
Hi, Sarah. Thank you. I just wanted to let viewers of the live stream know that we in the meeting are seeing a slideshow that they are not seeing at the moment, but we've posted it on the Vermont Judiciary webpage, which is www.vermontjudiciary.org. And viewers can go to the webpage. The banner at the bottom has an announcement of the meeting. And if they click on that, they can find links that will bring them to the slide presentation. That concludes my announcement.
Thanks so much, Pat. Anyone else have questions about what happened in Phase 1 or what Phase 2 might look like moving forward? I don't see anything in the chat. Okay, well, I will move on to the refresher on what is actually in Act 148. So first off, Act 148 establishes presumptive parole in order to reduce reliance on the furlough supervision system, which, if you remember from previous slides, was often the cause of a churn of people coming back to prison who were on community supervision. So in the beginning of the act, it establishes what conditions a person is eligible for presumptive parole. I'm sorry, I think I might have said probation earlier, but it's presumptive parole. So people are eligible for presumptive parole if they haven't committed a new offense They don't have any outstanding warrants. They're compliant with case plans and conditions of furlough supervision for 90 days, have no major disciplinary infractions for 12 months, and have not previously had their parole revoked. The Act also sets up the details of what that administrative review process will look like for the parole board reviewing presumptive parole cases. Presumptive parole is effective for unlisted crimes on January 1st, 2020, and listed crimes on January 1st, 2023. The parole board chair is also required to report to the legislature about the implementation of presumptive parole by January 5th, 2022. Next, Act 148 streamlines the furlough supervision system, reducing over 30 types of community supervision furlough to 3 statuses, which are temporary, treatment, and community supervision furlough. Additionally, within the streamlining, it requires DOC to conduct an internal case review and notify the Office of the Defender General regarding any revocation or furlough interrupts of 90 days or longer for a technical violation. And it requires DOC to recommend release to the parole board when someone is sentenced for an unlisted crime and has successfully completed 90 days of community supervision furlough, or is sentenced for a listed crime and has successfully completed 180 days of community supervision furlough. This furlough consolidation is effective on January 1st of 2021. Act 148 also increases the number of days that people are who can earn good time for people who are incarcerated or on furlough. So it increases from 5 to 7 days the time that people can earn off their minimum sentence, provided they have no major rule violation. Additionally, it requires DOC to notify victims of the changes to the Earned Good Time program and maintain a system that tracks the sentencing reductions. This is effective on January 1st, and emergency rules were required to be filed by September 1st, 2020. The next few sections of Act 148 actually included policy changes that were not vetted through this working group or the Phase 1 working group process. So these relate to some cleanup legislation, and then also requiring the prosecutor's office to ensure victims are aware of their right for notification of an individual's release date, requiring that law enforcement officers return absconded individuals with a warrant, and clarifies an escape violation on furlough. We aren't planning on providing technical assistance for this because none of these policies were actually part of the justice reinvestment process. All right, we're about halfway through here. So now we're out of the agency policy changes and into the additional studies and topics that the legislature would like to explore moving forward. So Section 19 of Act 148 directs Vermont to further analyze and develop recommendations related to racial disparities. So this really lives with, in the beginning, with the racial disparities in the criminal justice and juvenile justice system advisory panel, RDAP, and other key stakeholders to look into what is currently available on data and perform an initial analysis of the relationships between demographic factors and sentencing outcomes and make recommendations for legislative action. Then this passes on to the Vermont Sentencing Commission to review the findings of RDAP and other stakeholders and consider changes that they might make based on these findings to state sentencing structures or issuing non-binding sentencing guidance. The first report related to racial disparities is due to the legislature on December 1st of this year, and then the Sentencing Commission must report to the legislature on February 26th by February 26th of next year. Section 21 is where this group lives. This is the reconstitution of the JR2 working group to act as that implementation oversight body moving forward. I'm actually going to later in the presentation get into the details of what tasks are assigned to the working group in this section. But the really important thing to know here is that you all have a report due to the legislature on January 15th of 2021, and then again on January 15th of 2022. The next section of Act 148 directs AHS to work with
Can I ask a question?
Yeah, yes, please.
The last slide regarding the racial disparities.
Mm-hmm.
Do you know how that will work with the study that's being conducted by, and I usually get the wrong name, the Center for Justice Research at Norwich? They have a grant from the Bureau of Justice Statistics to study racial disparities within the criminal justice system. So I'm curious if this is all, are we going to work with them, or are we doing it separately, or how are we going to?
So Senator Sears, thanks for that question. And I actually see that I'm in my notes, but I think I might have forgotten to say that the Crime Research Group, who I think you must be referring to.
Yes, I am. They changed their name.
Yeah, they're written into this section to help out with the analysis portion of these duties. And I know that they have been meeting with RDAP and thinking this through, but I can't speak directly to that other grant or research study and how that might be fitting in.
Okay, thank you very much. That's helpful.
Okay, so we're on the last two sections of the bill that have policy changes. So there's also section 22 related to kind of additional work to explain behavioral health assessment, case planning, and information sharing practices with us working with the Agency of Human Services. So this section directs AHS to share how it identifies people in the criminal justice system who have behavioral health needs, how assessments inform case plans, and how DOC and community service providers currently collaborate on care coordination and case management, and where there are challenges in this information sharing. And that section actually has a report due to the working group on December 1st, 2020. So in just a couple of months. And last, Act 148 extends a deadline from an earlier bill passed in 2021, Act 88, that requires DOC to report to the legislature on a lot of topics related to how they supervise people on community supervision and housing. So it directs DOC to make recommendations and provide cost estimates on a host of potential changes, including formalizing the use of a 4-to-1 ratio of positive to negative reinforcements, staff training in graduated sanctions, and improving coordination and access to housing for people in the criminal justice system and with behavioral health needs. And that report is now due on January 15th, 2020. So again, I will pause here and see if anyone else has any questions on the contents of Act 148, the Justice Reinvestment 2 legislation. Okay, I don't see any chats or anyone waving, although I am not able to see everyone, but I trust someone will get my attention if you have a question. So I'll move on to CSG's Technical Assistance Plan. So we're thinking through our support of Vermont and of implementing Act 148 in 6 different categories. And I'm going to actually, rather than reading these out here, I'm going to go in a little more depth in the next 6 slides into the 6 different ways we're thinking through our support to Vermont. So first, there are these big policy changes within Act 148 related to the corrections agencies and the parole board. So that's the new presumptive parole process, earned good time changes, and furlough status. And for this, we're assisting DOC and the parole board with developing new policies and procedures to support these policy changes and facilitating a collaborative process between the 2 agencies to implement the mutual policy changes. We're able to provide hands-on support to DOC to implement department-wide, and also help them think through how they're going to communicate those changes and create staff training plans. We're able to support the development and implementation of quality assurance processes related to these changes so that the implementation continues smoothly. And then, of course, help identify and track relevant data metrics to measure the impact of these policy changes. Secondly, Act 148 has a state policy implementation goal of really evaluating how community supervision officers interact with people on community supervision and recommending improvements to increase the adherence of evidence-based practices and behavior change. And we're available to help support that as well, support further assessment on the use of how sanctions and incentives are used across the state, help develop policy and practice changes and officer training plans to strengthen the use of evidence-based responses to behaviors of people on supervision, and also to assist DOC in identifying data collection and other needs in order to formalize that 4-to-1 ratio of positive to negative reinforcements as recommended by research. Third, that relates back to Section 22, that section with AHS and thinking through the care coordination for people in the criminal justice system with complex behavioral health needs. So for this, we're able to assist AHS in analyzing current policy and practice and identifying and serving people in the criminal justice system with behavioral health needs. We're available to foster a collaborative process between behavioral health and criminal justice agencies to improve information sharing and coordinated case management, and then also to provide content expertise and examples from other states to inform changes to policy and practice in Vermont. Next is kind of what we're doing here today, which is provide project management and content expertise support to you all, the Justice Reinvestment 2 Working Group, as you work to monitor implementation and develop additional recommendations for improving Vermont's criminal justice system. So you all have seen already firsthand how this works, but in the future, we plan to provide content expertise to help you all understand your criminal justice system and assist the working group and state agencies in communicating implementation successes and challenges to state leaders and really understanding what's going on with your implementation. Another slide that works towards the data collection, data monitoring issue that we all know we want to work to improve in Vermont. So as you all work to increase criminal justice data collection and analysis capacity in your state and to set up the outcome measures to track the policy changes in Act 148, we can work with DOC, the Parole Board, and the working group to determine these data tracking measures and help the state agencies build their capacity to regularly track and analyze outcomes. We also support the analysis of that data as needed and help communicate the results to stakeholders. And last but definitely not least, we're available to help the state in supporting the identification of data gaps and areas for analysis related to racial disparities in your system. And so helping to support RDAP and the Sentencing Commission and all of the work they're doing to kind of to chart the path forward to better understand racial disparities in Vermont system and to propose policy options to address them. Right. I will again pause there and see if anyone has any questions concerning the type of assistance that CSG will be providing. Okay. Hope I've paused for long enough. So for those following along on the live stream, I'm now about to embark on slide 44, and this in the last section of the PowerPoint. And this is really to help inform a discussion for the working group on how you all want to set up your work moving forward, and just to set general expectations and next steps for how the project goes forward. So as implementation progresses, state leaders and the working group should be keeping an eye on key measures to understand if the policies you passed are having their intended impact. For example, the changes in how people are supervised in the community should improve their outcomes and result in decreased technical violations as people are more successful on supervision. This should also lead to decreased returns to prison for people on community supervision and hopefully therefore reduce your prison population. We also hope we know that these policies should lead to an increase in the use of parole supervision. We're working to help you increase your data availability. And then also, as you embark on particular sections of 148, really increase understanding of what racial disparities are in Vermont's criminal justice system and have a better understanding of the behavioral health needs for people in the criminal justice system. It's really important to remember that implementation takes time. Act 148 policies require a really large shift in how DOC supervises people in the community, and that won't happen overnight. As it will take some time to get data monitoring off the ground and then be able to see quantitatively how trends are changing in the numbers, there are some process-related milestones that you all can keep track of just to make sure that things are moving forward. And ensure that the implementation of the policy changes are on track. So we hope that in 2020, that subaward application will be submitted and the state agencies will be finalizing new policies and procedures for the three main agency-related policy changes. In 2021, your presumptive parole and furlough changes become effective. DOC will be reporting out to the legislature on their vision for how people should be supervised in the community moving forward related to sanctions and incentives. Your working group report is due, and then of course data monitoring begins and we begin to see what's happening in the numbers. In 2022, the big milestone there is that this working group has another report due, and then in 2023, the presumptive parole eligibility will expand. This timeline here displays the beginning of phase 2 and what will happen in the run up to January 15th, 2021, that reporting deadline for the working group and of course the next legislative session. Although it's not displayed graphically here, I do want to note that that the working group has these reporting requirements in 2022. So this is not the only time you all will meet. You'll need to be meeting throughout 2022. We just couldn't fit that on the slide. At this meeting here, we hope that you all will decide what your future meeting structure looks like, at least into the fall. I don't think we have to tackle 2022 quite yet, but how you would like to set forth your meeting structure and prioritize all the statutory duties in Act 148. And this is where you might ask, what statutory duties are in Act 148? Hey, Sarah, you skipped over them in Section 2. So here they are right here. There are a lot of them, so I apologize that this slide is definitely cramped. But in addition to providing oversight of the implementation of presumptive parole, earned good time, and DOC's efforts to improve its use of graduated sanctions, the working group has all of these other duties listed in statute. So those duties are studying earned time for people on probation and exploring other related policy options, identifying ways to increase DOC and community provider risk assessment information sharing to help inform plea agreements, sentencing, and revocation decisions, identifying screening, assessment, case planning, and care coordination gaps for people with complex behavioral health issues in the criminal justice system and recommend improvements, identifying new and existing tools to identify risk factors that can be targeted with treatment and services, studying presumptive probation, evaluating parole eligibility for older adults who have not reached their minimum term, and developing funding and appropriation recommendations related to all of these. So when you look at this list of tasks, 2 in particular are called out in the statute. as requirements that the working group report on them on January 15th, 2021 specifically. Those are listed or directly quoted in this orange text on the left of the slide, but are essentially the first 2 bullet points in this list here. So by January 15th, 2020, you all are required to suggest legislative action regarding probation and earned credit on probation, and how to ensure sentencing, revocation, and plea agreement decisions are informed by available programming, including community treatment programs and individual risk assessment information. Okay, you all have your work cut out for you. This is a lot of the working group to accomplish, especially running up to this upcoming January. While most, if not all, of your members will also be very busy with a host of other priorities. Because of this, we're recommending that the working group identify what you want to study first prior to January 15th, and then what you will work on throughout 2021 leading up to that January 2022 reporting deadline. Here's an example of what this could look like, but it's really important for us to receive your feedback on this, and that's the conversation I'm setting up moving forward. So know that this is really just an example or a draft to get people's kind of thoughts and thinking about what is most important to tackle first, and what can we accomplish before January 15th. So in this example that we presented to you, the first 2 are those 2 things that are statutorily required to do by January 15th, the studying of the earned good time on probation and increasing that information sharing at particular points in the system. And then we're recommending here, we've drafted here an idea that you would also begin to tackle identifying those tools for risk factors for targeting treatment and services, and beginning to identify kind of wrapping that into all the behavioral health screening, assessment, case planning, and care coordination gaps. And then what seemed like would be more difficult to get to before January 15th, we've added at the end. So as time permits, we can try to get to studying presumptive probation and exploring the parole eligibility for older adults. So this really kicks off the next agenda item, which are the discussion topics for today. These are really the important questions that we ask you to consider so that you can give us direction on how to move forward with this process. So these are, what will the working group's meeting schedule be between now and January 15th? How can CSG staff help prepare you for productive, efficient meetings? I think it's important to note here that along with meeting schedule, we should probably discuss meeting duration, as those 2 may impact each other, how long folks can meet, depending on how often it is. And then also setting up what's on the last slide. So given this tight timeline before January 15th, how would you like to prioritize those statutory duties in Act 148? And then if there's time, I think it's really important to start thinking through what sustainability mechanisms you might want to set up. So you all know that you have a report due in 2021 and at the beginning of 2022. But implementation is a long process. Everything's not going to be picture perfect when your first report, when your second report is done in 2022. And just to think through how you all are going to be thinking about sustainability into 2023 and beyond. So that is it for me, although I do want to pause for questions again, see if anyone has any thoughts initially on what I presented in this last section, and then or wants to dive into this discussion of how you all want to kind of frame up your time moving forward.
Sarah, this is Paul Reiber. If there are no questions about the last segment of your presentation, maybe we should first discuss a meeting schedule for the working group between now and when the report is due on January 15. Does that sound right?
Yeah, I think that makes a lot of sense.
And I might discuss I might suggest a monthly schedule, but I don't know how that suits what you contemplate and what others may as well.
Yeah, how I've been thinking about this is I think you all met about monthly last time. It probably makes sense. There's a lot of work to do, but just to be cognizant that today is September 30th. And so if you all choose to meet at the kind of the end of the month, moving forward, that means that we run into all of the holidays. So also, thinking that through, and maybe because today is the last day of the month, we actually kind of consider this the first week of the month. And so, consider this the first week of October, and then perhaps meet the first week of November, December, and then January, which would at least help with most of the holidays, although not exactly New Year's.
I guess, what do other folks think about that?
Yeah.
To say, Alice, I would be careful about trying to schedule anything in November 3rd. That is an election day, and there are some of us who are up for re-election. And it's a little crazy leading up to it.
Good point.
Right after it, some of us were a little tired, like the following day. So it would be worth it to have another meeting in October, like around the 20th or 25th, and then schedule something in the middle of November.
And then one in December as well, Alice?
Yes, you'd have to do something in December, but
Middle of
I'm
December.
just putting that out as
Yeah.
For our candidates. There's 4 of us that are candidates here.
Yeah, no, that's a great point. But it would work.
I agree with that.
Would it work if we had a meeting the end of October, towards the end of October, middle of November, middle of December? Everybody think that would work all right? What do you say, Sarah?
I think that generally it takes CSG about a month to be able to get things together. So to be able to have kind of that successful conversation and present you all with the analyses you need. So if we're able to get that as close to monthly as possible, that would be really helpful just on our end. But that sounds pretty close to monthly, so I imagine it could work.
So maybe the last week of October, Alice and Dick and others who are in the middle of that.
The last week, other than the 27th, which we have CSG Justice Center board meeting that day, I think. Other than that, I'm fine with that, with the last week.
Maybe do it more on a Monday, the 26th, because if you wait too much to the end of that week, then you're on the heels of last minute campaigning.
Yeah, you could actually do it the morning of the 27th as long as I have the Justice Center board meeting written down for the 3 p.m. on the 27th. So that's all I.
So the suggestion is the morning of the 27th. It'd be a 2-hour meeting, meet at 10 o'clock Eastern, and
sounds like a good idea.
Does that sound all right?
Sounds great.
How about everybody else?
That's
yeah.
Okay.
Yeah, Sarah, is this going to work out for you?
Yeah, so you're saying from 10 to noon on the 27th, on Monday, or the Tuesday, the 27th?
Tuesday, that's right, yeah.
Yes, yep.
Okay, hearing no dissents, we'll say that's the first one. What about the second one being, well, the week of Thanksgiving? We could do it Tuesday, the 24th. That's about a month later. But maybe that's not a good week. I don't know. What do folks think? Tuesday
with me.
morning? Is it Tuesday morning, the 24th, 10 to noon? Is that okay with everybody?
Yep.
Yeah? Okay, hearing no dissents, we'll say that one. And December 22nd? That's a week, that's just before Christmas. Is that okay? 10 to noon? That's a Tuesday? Yeah? Again, no dissents. Okay. All right. Sarah, do we need to schedule one in January before the 15th as well?
I have to say I'm not quite sure. I'm also not quite sure if we might need longer meetings than 2 hours to cover all the materials. I think it might depend on how this conversation goes and how you all tell us what you'd like to cover and prioritize. Meeting before January 5th, if we're having a meeting right before Christmas, I have to be honest that, doing another presentation for us right after New Year's is definitely going to be pretty difficult. But we could facilitate a conversation or do something less analysis heavy, I suppose. But that will be, our offices are closed between Christmas and New Year's. So that's for the CSG team, not really, I would say, giving us work time to prepare for a second meeting right that first week in January at least.
So are you saying you'd not be okay with December 22nd? Is that what you're saying?
Oh, no, I'm sorry. I think if the committee finds that December 22nd works for folks, we will definitely make that work. I'm more concerned about doing a December 22nd meeting and then turning around and doing something again the very early in January.
Yeah, I can understand that. Well, maybe if we target those 3 dates, unfortunately, I didn't write them down, but they're 4 weeks apart. October 27 is the first one, November 24 is the second, and December 22nd is the third. And we say, at least for purposes of discussion right now, that there'd be 2-hour meetings, and we can adjust that as needed. We could move now on to the question of what the priorities for the working group are, right? Is that your vision for this discussion? Sarah, you're muted.
So sorry. I do want to acknowledge I just saw a chat pop up about how this might be a little difficult for parents who might have children out of school in December.
Okay, that's a good point. Well, would you like to skip a December meeting and just schedule one in January? Would that make sense?
I think that could make sense, although I would defer to the legislators who might be leading up to the session and what you think would be most helpful for you all in understanding what's going on and what the recommendations might be.
I can't remember when we're due back. I don't know. There's you remember. Is it January 6th we're due back?
Yeah, that's a Wednesday, Alice. That sounds right.
Yeah, we go back on Wednesday, the first week of
That's
the
a week
session
after
of biennium.
Yeah,
So
that's a week after New Year's.
if you do it before we go back, you could do it on a Monday. Tuesday would be a little tight, but you could do it on a Monday or Friday on the previous week. What date is that?
So that's the first.
That's the first. That's what I was
Yeah.
thinking. So you'd
Yeah.
have to do it that Monday or the following Monday.
What about Monday, the 11th? January 11th?
I think Dick
I
wants
think
to
that's
speak.
safer. I think the 11th is safer because people, who knows who's going back, but assuming that the 4 on this call are back, I would think the 11th is better. Usually, we
Well,
have. few
What do
meetings
people,
that day.
what's everybody think about skipping December altogether? The last meeting in 2020 will be November 24, which is the Tuesday before Thanksgiving, and then we meet again Monday, January 11, 2021.
Sounds good to me.
As long as we can
Any-
get our work done.
Yeah.
I wonder if we reserve the right to extend the meeting time past 2 hours, either in January or maybe previous to be able to cover all the topics. So I don't know how people feel about that. Maybe start with 2 hour meetings and
Well,
later to extend them, or just start with 3 hour meetings. And if we end early, everyone can feel better.
Yeah, we could block out 9 to noon on those 3 dates if people are okay with that, and then see how it goes.
Yeah, that's fine.
Is that all right with everyone?
Mm-hmm.
Fine with me.
All right, so we'll say 9 to noon on those 3 dates. Do people want to hear them again? You got it in mind?
We'll also send out calendar invites to everyone, but happy to have people write it down now as well.
Okay, so Sarah, talk to us about priorities. I mean, the thing that, seems just common sense is that the two identified items that the group is required to report to the legislature on by January 15 have got to be the first two things that we work on. Beyond that, I think we all would probably appreciate your guidance as to whether or not we ought to be talking about additional items as well before we get to the January 15 deadline. I'm not quite sure how to think about that. Maybe you could help me at least think about it.
Yeah, would it be helpful to share that list again if I shared my screen again, or do you all have it kind of in your meeting materials?
I think that's a good idea.
Okay, let me get that up and running again. Just 1 second. Okay. Thank you for bearing with me. We are almost there. Okay. Can you all see this list?
Yeah.
Yeah.
Okay. I mean, I'm really interested. So the first 2 bullets here are what is the statutory January 15th deadline, as the chief said. So we know those are on the agenda. There's also the next bullet points are kind of around behavioral health, identifying screening, assessment, case planning, and care coordination gaps. And this also relates to AHS's deadline to submit a December 1st report to you all. So that kind of is on the agenda in some way, since there is a deadline there. And then identifying new and existing risk tools to identify risk factors, to target treatment and services. So also mostly related to behavioral health, studying presumptive probation, then the parole eligibility for older adults, and then any funding and appropriations recommendations. So my understanding of this, and please anyone jump in and correct me if I'm wrong, but these were a lot of items on this list were based on ongoing conversations that happened during the 2020 legislative session. And unfortunately, I don't have the best window into what exactly those conversations were, or perhaps what some folks' priorities are in getting policy changes through in the next session. So having more understanding of that, I think would be really helpful beyond the 2 that are prioritized for January 15th.
Well, this is Alice Emmons. I think one of the important pieces of our Justice Reinvestment 2 is to really look at behavioral health issues and really look beyond DOC, look at their community partners, particularly folks within the Agency of Human Services, such as Economic Services or Department of Mental Health or Aging and Disability, and bring those partners to the table, because if we really want folks to be successful in reentering in the community or even serving probation in the community, we really need our community partners to be engaged. And I think that was one thing in the legislature that really came out. Everybody looks to DOC to provide all of this, and that is beyond what DOC can provide. I think really looking at our community partners and the behavioral health issues.
And Alice, are you saying that that would be if we were to begin ordering these numerically, and if the first two, there's 7 of them, there's 7 bullet points, and the first 2, as I understand it, are the 2 we're required to report on by January. So the third one you're saying would be, where is it? I'm looking for it.
Well, I would think one of the first ones would be the behavioral health, right? Maybe not. Was there a report, Sarah, needed to be submitted to the Agency of Human Services on December 1st?
Yes, and that is submitted actually to the working group as opposed to other reports that were submitted, to various legislative committees. So it's true that by the December, well, we no longer have a December meeting, but so perhaps on that November 22nd meeting, if I'm getting that date right, we'll want to, the working group will want to hear about that work done with AHS.
Well, the third bullet point is the behavioral health issue. So if we were to number these bullet points, they would be in exactly the order that they appear on the screen right now, right? Alice? Does that sound right? So because the first 2 are the required January report, the third one is identifying complex behavioral health issues. Would you actually move that up into the ahead of one of the first 2?
Well, I'm almost thinking of that because of the Agency of Human Services report, but I don't know.
Oh, because of the December deadline, I see.
Yeah, I don't know. I mean, I'm just putting that out.
Chief Justice, this is David Demora from the CSG Justice Center.
Yeah, David.
I would argue that bullets 2 and 3 are, though they are separated out because of content, they really are of a kind and probably will be and should be attacked together, because really some of the answers to 2 rely on some of the information and answers from 3 and vice versa. So while they are separated out, I would argue that we would attack them, so to speak, as one.
That's helpful, David. Does that help, Alice?
Yes, it does.
Because I think your point about the reporting deadline in December is a good one, and it would make sense if we were to put it off. But part of this is a question of how much. I mean, you folks at CSG do the heavy lifting on this. I think you've got to give us some sense of what is doable from your point of view.
I mean, I would think, and David, I would be curious to hear what you say, but given that we've outlined 3 meetings moving forward, that tackling kind of these first 3 bullet points could easily fill 3 meetings. I see Representative Emmons agreeing. So I don't want to feel like I don't want Vermonters to feel like the process is delayed, or that, that you all might want to see kind of a more robust agenda. But I think that we can But I think that if we want to do in-depth and have really in-depth conversations, there's a lot to chew on in just those top bullet points. And then but just to be clear, that would leave discussing presumptive probation, the parole eligibility, and perhaps some additional behavioral health, kind of more in-depth behavioral health things related to that fourth bullet point, to 2022, if folks can live with that.
So Sarah, clarify this for me. Your thinking is that let's just talk about the first 3 bullet points on your page here. Your thinking is that each of the 3 meetings that we have identified before the January report would be devoted to one of these 3 bullet points. Have I got that right?
I think based on what David said, it wouldn't be so clean, Chief, in that some of these bullet points do build off of each other, particularly 2, 3, and maybe even 4, honestly. We will have to, we'll have to go back as a team and think through kind of the logic of how to present these, but they're not as discrete, actually, perhaps as the bullet point structure kind of demonstrates here.
Well, do we need then to order a priority within those 3 or 4 first bullet points on the page, just for the purposes of these next 3 meetings? Should there be an ordering of some sort of those? Which of those ought to be first and second, third, fourth, whatever?
Okay. So, Chief Justice, this is David Demore again. I'll certainly leave it up to Sarah as to which should be first. What I would suggest, however, is that bullet points, when it comes to the behavioral health piece, to bullets 2, 3, and 4, I would suggest that we would do bullets 3 and 4 first, and then we would do bullet 2 after that. Now, whether you want to put those before the earn time or not, that's up to you all and to Sarah. But I would argue that it would make sense to do the identifying new and existing tools and the screening assessment bullets as one, and that be a meeting. And then the result of that, an ongoing discussion, would be another meeting focusing on the identifying ways to increase DOC and community provider stuff.
Yeah, well, David, does it make sense though to do 3 and 4 before the December report is due?
And I'm sorry, Chief Justice, you broke up. Could you please repeat the question?
Yeah, does it make sense to do bullets 3 and 4 before that report is due in December?
From my perspective, 3 and 4 need to be done in order for that report in December to have the content that it needs.
Ah, okay, I didn't realize that. So then, I mean, doesn't that mean that we should do 3 and 4 in the October and November meetings, or one of them? I'm not sure how it should work, but we've got 2 meetings before December. How would you split those up?
Sarah, do you have an opinion?
Well, I'm wondering if we just tackle behavioral health first, is what I'm hearing, and that's kind of all as far as we can get on 2, 3, and 4, and then that would leave till January the discussion for people on probation and earn time or other related policy options. Alternatively, we could also we could discuss both in one meeting. We could continue to have behavioral health as kind of a standing item as we work our way through those items and meetings, and designate some time earlier for the earned good time on probation, so that by January we have more of a direction in that meeting. I'm trying to think, because I guess it's 2 meetings before January. It's a tough one. It's a little bit of a quandary.
Yeah. Anyone have any other thoughts about this?
Sounds okay. I don't think anybody can hear me.
Yeah, I can hear you. It seems to me then that bullets 2, 3, and 4, and I'm sorry they're not numbered, but everybody knows which ones I think I'm talking about. And from what Sarah and David are saying, those 3 go together. And I gather what CSG would like to do is to split them up between the 2 meetings we have before January, the October 27 meeting and the November 24 meeting, and then do bullet 1 at the January 11, 2021 meeting. Does that sound right? Sarah, is that what you're thinking of?
Well, that is an option. We are, I guess that is one of the options I put on the table. I think that we could also see so if we have essentially 6 hours on the books in 2020 before the year ends, we could see how far we get. In 5 hours on behavioral health and designate 1 hour for probation or 2 hours for probation, and maybe start thinking of it less in meetings and more in proportions of time available, I suppose. And I might just be making it too complicated.
Well, I think you're going to have to draft the agendas for these meetings. I mean, I think that it's going to fall on your shoulders to do that and figure out what the best flow is, to get the most discussion going, which I think is the point. We want to make sure that there's a healthy discussion about these issues fundamentally. And so, the agenda and how you lay out the agenda and the sequence of the agendas between October and November meetings, I think is going to be fairly important. But it sounds like we have an understanding. At least I think I do. I don't know about anybody else. Maybe nobody else has an understanding, but I think I've got some idea of what we're talking about.
So actually, what I'm realizing is, one, that I really should have numbered the slides. So apologies there. And the next time you all see this list, it will definitely be numbered if we need to present it again. But thinking this through and thinking how we've just determined that 2, 3, and 4 all kind of go together, and there might be a process around them. Maybe it actually makes most sense to tackle earned time for people on probation first, while we're doing more in-depth work with AHS and the other folks that need to be at the table for the behavioral health. So we could talk about earned time for probation in the next meeting. Set up the behavioral health conversation, really dig into that right before that December 1st reporting and deadline. And then once we're there, determine what we need to cover in the January meeting.
That sounds wise to me. But Alice, Dick, what do you two think about this?
That will work. I think that will work.
I think it's a good plan. The one thing we have to do is put together justice oversight committee meetings as well. So keeping all that in mind, I don't want to overburden everybody. I think there's some reports due to justice oversight.
Did that slow us down in making a decision here now?
We can always.
All right, so I think unless, I'm sorry.
No, I'm fine. I'm fine, Chief.
Right. Unless there's a naysayer here, as I said at the beginning of the meeting, please passionately at your camera if you can't be heard. I think some people are having trouble with the mute button. But as I understand it, Sarah, the first bullet point is going to be the subject of the meeting on October 27. And then you guys will approach the November 24 and the January 11 meetings with for a discussion and of the second, third, and fourth bullet point. All of this before the January 15 meeting, and I would think down the road we can then talk about the last 3 bullet points and what our priorities would be for them. But, you know, we're going to have to schedule more meetings in 2020 and 2021, unless you anticipated we would do that now as well. No, you're muted, Sarah. You're being too dutiful to the instructions. You're muted again.
Oh, I'm so sorry. Yeah,
That's
you're
all
just fading. I was just letting you know that you were, at least for me, fading in and out a bit, and I'm not sure if everyone can hear you clearly.
Yeah, I'm sorry about that. It's a computer audio. I don't know if that's the reason. Did you hear enough of what I said so you understood how I maybe I'll turn my video off. That would help, wouldn't it? How do I do that? Okay. Is that any better? Is that better?
Yeah, you do sound more clear.
Okay. So what I said was, if we take, we'll consider, based upon this discussion, that the October 27 meeting will be about the first bullet point on this page. And then the 2 meetings, November 24 and January 11, will discuss the 2nd, 3rd, and 4th bullet points. All of that to take place before the January deadline for So somebody needs to mute, I think. I'm getting a lot of background noise from somewhere. Anyway, does that sound right? Did you hear that, Sarah?
Yeah, I think that sounds right. And we can take this and run with it and look to propose a kind of more concrete structure to you all via email on what we think that this means. And just want to confirm that everyone is okay with what's not on this list. So what the committee is taking on is kind of planning on taking on in meetings in 2021 rather than leading up to January 15th. And as long as no one is speaking up and saying that there's anything that we're not getting to that gives them heartburn, then I feel good moving forward.
Okay, good. And the other thing I had said was I would assume it's not necessary for us now to schedule the rest of the 2021 meetings and discuss the priorities of 5, 6, and 7 bullet points on this page. We can wait to do that, but am I right or wrong about that?
I think you're right about that, and that once we get through this kind of sprint of a working group process, we can return to figure out what 2021 looks like.
Okay. Okay. Well, thank you. And you'll put all of this in minutes of some kind that are going to come out about this meeting. So we have dates and agenda items. That's going to come out to everybody at some point after we conclude here today, right?
Chief?
Yeah, Dick. Yeah.
Question.
Yeah.
Sarah, what some recommendations? Is that for the legislature in 2020, in fiscal year 2021 or fiscal year 2022? How do you see that?
I in my memory, and I would have to go back since this is a summary to the exact bill text, but I believe that was for both the 2021 and 2022 report that, any policy changes that suggested to be accompanied with those recommendations.
Well, we did in the budget that we just passed last week, kind of did a around any savings from out-of-state beds being reduced. So, but we do need to, that process will start in December for the administration and then early January for the, in the House meeting in December. They usually do after the election. And obviously this year there'll be a new chair, so I'm not sure if they'll be ready for that. But so we we need to, if we're going to do stuff for FY22, it kind of needs to be we should be talking about that at our, we're not doing a November meeting, so definitely discussing that in our December meeting.
No, it's,
Oh, it's November we're not doing December.
yeah, that's it, Dick. We're doing November 24. Yeah.
Okay, I'm still getting a little confused. So.
No, I can understand why we went back and forth.
We should be talking a little, if possible, about funding priorities on the 24th of November.
As little as possible or as much? I'm sorry.
I mean, whatever. I just think that to make sure we continue to look at community-based services as part of justice reinvestment.
So it sounds like with that timeline at the November 24th meeting, and I think this aligns with some information I've heard elsewhere, that, the earlier the better to understand, what funding might want to be recommended to support these recommendations. So that funding conversation should be in the November 24th meeting, right? Just want to make sure I'm tracking. Okay.
Yes, that would be helpful.
Okay. We can definitely do that. I mean, I think that we have a lot to build on from last year, from the last working group process as well. And I do, we're not starting from scratch here. We plan to build off the phase 1 team's work and all of that effort and analyses that they put in moving forward. So I think that that's really reasonable.
Okay.
And to answer the Chief Justice, I'm sorry, Senator Sears, were you?
No, I was just thanking you.
You're welcome. To answer the Chief Justice's prior question, we will definitely be writing up all of the key notes, key decision points, and sending them out to everyone, along with meeting invites and our recommendations. So you all will get something in writing that you can kind of see and respond to as well.
Okay. Thank you, Sarah. Thank you very much. We're actually just about on time with the agenda, but I don't want to move forward unless anyone has another comment or a question about everything we've covered so far. All right, hearing nothing, we're going to turn to Roman numeral number 4 on the agenda. DOC.
Hi, everyone. Can you hear me?
Hello. Yes,
Hi.
thank you, Monica. Yes, thank you, Monica.
Hi.
Hi.
I'm Monica Weber. I'm the Administrative Services Director for the Department of Corrections, and Sarah asked me to provide a 5-minute update on the implementation so far of Act 148 that the Department of Corrections is proceeding with. So I'll do my very best. I could have taken the entire hour and 40 minutes we've already been on this call to give you an update. I also wanted to call out Dale Crook, who is on the call with me as well. Dale and I are leading the implementation for the department. And we really kicked off the implementation in June, before Act 148 was actually passed. We had a launch meeting. We started and organized an implementation team that consisted of myself and Dale, other sort of subject matter experts, our senior probation officers who are staff who provide a lot of support and training to other field staff, reentry caseworkers, and just a lot of support people, our database manager, our policy director. So since that time, the Department of Corrections has been meeting very regularly with very focused meetings several times a week. We've really created some sub-teams to tackle each one of the strategies that's been outlined in Act 148. And those really are around good time and implementing the Earned Good Time program, the changes to parole and presumptive parole, and the whole re-envisioning of furlough.
Did you get that? Did you get that for me? I'm
Oh,
on Zoom.
okay.
Could you say?
That wasn't for
Yes,
me.
I can't
The
talk.
whole re-envisioning of furlough and what that means in terms of how people are organized or how people are supervised in the community, in particular, what violations look like in the violation process. So we've been working through all of that and really taking the research and the evidence that's out there in the criminal justice arena, reviewing that, getting a lot of information from our friends at the Justice Center. Once the technical assistance started, they have been joining a lot of the meetings and providing us with information. And rewriting our policies, rewriting our procedures, and looking at the types of training that we need to provide to our staff. I see that my video seems to have been stopped, so I hope you can all still hear me. Can you still hear me? Yeah, okay, good. So just a few small things. So regular meetings, and the focus has really been also on trying to have regular communication with our staff. So we have some bi-weekly meetings where we invite other staff who may not be involved in the detail work to just join and listen to what's going on. We created a communication brief that we've sent out to staff, but we've also sent that to our everyone who's incarcerated. So the inmates all received the brief on their tablets to explain the changes that are coming. And we're developing a FAQ because we got a lot of questions from that brief. In addition, we've been having regular meetings over the last month with the parole board. I know MJ is going to talk about what they're doing, but we're starting to work collaboratively on the implementation of presumptive parole and just the changes to the parole process. As Sarah noted, there were some deadlines around the good time rule filing, and so we have filed the rule per Act 148. We filed the emergency rule and the standard rule, and we were going through that process with LCAR and ICAR and putting together all the pieces so that good time will also be
in
effective.
Royalton, but I'm coming home for dinner, or you could come with me to.
Sorry, excuse me. I went ahead and just muted everybody on the call. So just a heads up.
So am I still?
No, we can hear you, Monica. Go ahead.
Okay. I'm still good. Okay. My WebEx seems to be doing something strange, so I'll try and finish up here quickly just in case it crashes. Yeah, so with the goal of really putting all of these pieces in place to start January 1st, and I think the important piece of this is we're starting implementation, as you know, and moving through all of the, I would say, details, and the kinks of it will still continue throughout 2021, but we're really positioning ourselves to be able to start per the January 1st effective date.
Okay. Thank you very much, Monica. Thank you. MJ Ainsworth, an update on the parole board, please.
Good afternoon, everybody.
Good afternoon.
I was having issues with my buttons for a moment. Sorry. Currently, the parole board has been working through rewriting some policies around the parole changes that are in Act 148. The biggest one is around presumptive parole and really looking at what our administrative review process is going to be. The other one is around the new timeframes, or the more simplified timeframes that were created around subsequent reviews for parole. instead of having differences depending on sentence structure, now everybody who is not on parole will be reviewed every year. We've been meeting bi-weekly with CSG to help look at some ways that they can provide technical assistance to us. Some ideas are around helping with some evidence-based training, looking at potentially how to revalidate our risk assessment tool because it hasn't been revalidated for years. Also around maybe some joint training between DOC and ourselves. Chairman George and I have been working with the board members since this bill kicked off last legislative session to ensure the board was well communicated with to know what is occurring, because there's going to be some cultural shifts with more individuals being placed on parole versus on furlough. Historically, there was kind of a crutch of furlough if somebody was on parole and violated, or the parole board would look at somebody going out into the community on furlough. So there's some cultural shifts going to be occurring there as well. And there's also been some discussion between DOC and the parole board around the subaward, which Sarah had mentioned earlier in the discussion and in the slides, around potentially a position that would be looking at data integrity. That is the discussion that we are proposing together. The position would be joint to ensure that data is being entered correctly and folks are trained properly on how to do that. That's the bulk of the updates that I have.
Okay, thank you. Thank you, Mary Jane. I think you and Monica are going to present now on the Category 1 subaward funding.
MJ and I did not talk about how to do this. MJ, do you want me to start, or how do you want to proceed?
If you would like to start, I already kind of kicked it off because I missed
Sure.
the agenda. So
Okay.
if you'd
Yeah.
like to continue, go for it.
Okay. So I think as Sarah mentioned, a few times the Category 1 funding can be used to provide funds for a position. And one of the things that also got highlighted in phase 1 of Justice Reinvestment was this real sort of capacity issue in the state to have data available. And we know that because there's so much data monitoring involved in this phase 2 aspect of it, and because the parole board and the Department of Corrections essentially use the same data system, we are together requesting that the working group support an application for a position that can really support data collection, data integrity, and the data monitoring that needs to happen as part of this process. And so we've talked about what that position could look like and how we would share that position to support both needs of the parole board and the Department of Corrections. And we've looked at various, job types that the state already has classified and thought about the types of skills that we would need. We think that that position for a few years could possibly take up about half of the $500,000 that is available for the subaward. And then there's been other discussions around the Category 2 funding, but we can talk about that later. MJ, what else would you want to say about that?
No, I think you hit most of it on the head. I think the other key piece that I've identified with this data position is also looking at training, because with data integrity, staff also need to be trained in how to enter the data as well.
Right. And that would be true for parole board staff, but also, for Department of Corrections staff, most of the data that we all are using when we're evaluating, various things like violations, a lot of that information is put in by our staff, right? And so what we anticipate is that this position could also be a support to monitor the quality of the data that's coming in and help to ensure the integrity and consistency of the data, so that when we actually get to the point of analyzing it, we're really confident that it's accurate information.
Okay. All right. Well, thank you both very much. Does anyone have a question or comment for Monica or MJ? So we're running a little ahead of schedule. I appreciate the timeliness of moving through the agenda. I don't think we need to have further discussion, Sarah, unless there's something more that you want us to touch on before we close.
Sorry, just taking a second to get off mute there. No, I just want committee members to make sure committee members understand that we're going to move forward with helping Monica and MJ develop that Category 1 application so that they can get this person in place as soon as possible, as Category 1 funds are supposed to be sent. And so I hope that there are no objections to that, so that we can move forward and making sure that you are hitting those deadlines and getting your data person up and running. So I'll just pause there in case I don't see anyone.
No, I don't
Okay,
see any.
perfect. Perfect. So we're going to move forward with that, and I think for CSG's part, for closure, just to repeat that you all will be receiving a lot of information from us as a follow-up from this meeting, kind of outlining calendar invites for those next 3 meetings and outlining, how we propose we tackle all of this, and just really appreciate the thoughtful discussion that we had around the priorities and statutory duties of this group, and hoping that we'll have some very productive meetings moving forward. Really looking forward to it.
Yeah, thanks very much, Sarah. Thank you and your colleagues. You guys are terrific, and I appreciate the work you do in support of our state and the people of our state. And thanks very much to all of you who have joined us this afternoon. We'll look forward to our next meeting on October 27, starting at 9 a.m. So that's the end of the meeting. Thanks very much. Good to see everybody. Be well. Take care.
Thank you, Chief Justice.
Thank you,
Sarah. Thanks a lot.